Joined now on Zoom by Lawrence Tribe, the Carl M. Loeb University Professor of Constitutional Law Emeritus at Harvard University, and Nancy Gertner, retired federal judge, senior lecturer at Harvard Law School, regular BPR contributor. We're going to talk about some of the legal issues confronting Donald Trump, and we will also talk about a matter that could have profound effect on Ukraine's ability to protect its democracy. Larry Tribe, Nancy Gertner, thanks so much for your time. We really appreciate it.
Good to be here.
Yeah, thank you both for being here. So I just want to talk about this morning. Trump showed up in court in New York City, and before he went into the courtroom, he called Letitia James, the Attorney General, a racist, and he referred to this case as the biggest witch hunt in history, or words to that effect. Here's a little bit more about what he said before entering the courtroom for the start of the civil trial against him, his eldest sons, and their companies.
There was no crime. The crime is against me because we have a corrupt district attorney, but we have a corrupt attorney general. And it all comes down from the DOJ. They totally coordinated this in Washington because I'm the leading candidate. I'm leading Biden by 10 points. And I'm leading the Republicans by 50 and 60 points. That's pretty much, they say, over. I never accept that, but they say it's over. This has to do with election interference, plain and simple.
So let's start with you, Judge Gertner. Are you surprised that Trump showed up at all to sit in the courtroom? Maybe it was to make this statement. I don't know. What do you think of his coming to the courtroom?
Well, I mean, now that I heard his statement, I'm not surprised that he showed up. He doesn't have to show up in a civil case. He didn't have to go at all. And it's clear when you listen to the last line about election interference that he wants to fold this narrative into the narrative that got him in this trouble to begin with, which is, you know, this is in election interference just like they did in 2020. It resonates with what the Judge Chutkan in the election criminal case in DC is going to have to do, which is to figure out how to gag Trump. In the civil case in New York, that isn't an issue. It's a judge trial. So that isn't an issue. And he therefore feels he has a free runway to say whatever he wants about the judge and the attorney general.
I think, Judge Gertner, you missed something. The judge in the Washington case is also a racist and deranged, which explains what's happening there,
Right.
obviously. So,
Right.
Larry Tribe, if you're dying to comment on that, feel free. But can we get to my obsession, which I think is, I hope, one of yours, this 14th Amendment Section 3 thing. For the three people who've been living under a rock, let me read the relevant portions of Section 3. No person shall be a senator or representative in Congress or hold any office under the United States who shall have engaged in insurrection or rebellion against the same or given aid and comfort to the enemies thereof. You and a guy who used to be the darling of the right, at least in the judicial world, Judge Ludig, have taken the position that this language is self-enforcing, which means, at least to me, you don't need a determination by Congress. You don't need a court ruling, that it is self-enforcing. Can you explain in Cliff Notes fashion what that means to mere mortals, Larry Tribe?
Well, you do need a ruling by somebody. There's nothing in the Constitution that sort of steps up out of the page and grabs you by the throat. So calling it self-enforcing is a little bit of a misnomer. What that really means is that, like everything else in the 14th Amendment, like the Due Process Clause, the Equal Protection Clause, this doesn't need congressional legislation to bring it to life, but it does need somebody, and the somebody is going to be either a Secretary of State. Many of them have been sued because under their state's laws, they're not supposed to put anyone on the primary ballot who fails to meet the eligibility requirements for national office. In this case, those requirements include not only being 35 and a natural-born citizen and not having run 2 previous times and won the presidency, but also not having taken an oath of office to the Constitution and then turned against it and tried to overthrow it by an insurrection. Those secretaries of state are uniformly saying, not me, I'm not going to do this. So they're all being sued. They're being sued in the highest court of Minnesota because the laws there allow voters to bring suits directly there in order to keep disqualified people off the ballot. They're being sued in the lower courts, in a Denver municipal court, actually, in the Colorado case. They're being sued in the Court of Claims in the state of Michigan. In each of these cases, the people bringing the suits are eligible plaintiffs under state law, but in all of them, they do not have standing under federal law. What that means is that if Trump wins all these cases, and he might, it'll never even get to the Supreme Court of the United States, because the losers will be ordinary citizens who, under federal law, don't have standing. It's only if one of these state highest courts says, okay, we're reading this language, we understand what it means, we've read all the scholarship, it really does disqualify Trump. It's only if one of them says that Trump then gets to review that decision in the US Supreme Court, where I don't think you have to be a wizard to figure out that the court is not likely to be sympathetic to the plaintiffs.
You know, representing the non-lawyers out there that are listening, and I'm not a lawyer, I've learned a lot about this 14th Amendment. Judge Gertner goes back to the Civil War and the Confederacy. Tell people that don't know this history here.
Well, there's really, people should go read the history, because it's really quite extraordinary. It's extraordinary in terms of what motivated it, and then when it failed to actually disqualify Confederate officers, what happened. It was a way of disqualifying a part and parcel of the enforcement mechanism of the 14th Amendment. To enforce the 14th Amendment had to require the disqualification of people who were Confederate officers, Confederate officials who had sworn an oath to the United States, to the Confederacy rather, and then after the war tried to run for office or achieved office rather in the Confederacy. And this was to stop that from happening. It's really a simple principle that if you took up arms against your country, you can't then be an official of your country. Many of the Confederate soldiers, however, of the officers rather, there was a broad amnesty, which then enabled them to run for office, and when they got in, dismantle some of the what was essentially a biracial democracy in many of the states that had been in the former Confederacy. So it was intended to prevent that. Ultimately, the political will failed. But the point is that even though there was an amnesty for some Confederate officers, in fact, not the provision of the 14th Amendment never changed. It continues to be what it says. And there really is an extraordinary group of, not just liberal scholars, but conservative scholars who believe that the language is what the language is. It says disqualification should be a disqualification. Just following up with Larry's point, it's the same thing as if somebody who's 28 wanted to run for president. The Secretary of State would look at his birth certificate and say, you're not qualified. End of discussion. Likewise, if Trump goes into those Secretary of State's offices and says, I'm Donald Trump, I have 91 counts against me. I have, I was obviously some participation in the insurrection on January 6th, and the Secretary of State could say goodbye.
Speaking of, I had some involvement in the insurrection. How about the argument, Larry Tribe, that the Department of Justice through Jack Smith could have, but chose not to indict Trump for insurrection? Does that not carry some weight in terms of this 14th Amendment argument?
Actually, it doesn't. It's neither necessary nor sufficient to be convicted of insurrection or indeed of anything. The reason is that this provision was designed as a backstop in circumstances where the executive branch might be disinclined to prosecute. Andrew Johnson was the president of the United States when this became part of the Constitution. Far from having a Justice Department that wanted to prosecute anybody, he was in the business of pardoning Confederates. But lest we think that this is all just history, and history is important, but for people like Nancy and me, history is certainly not everything. This could have been a provision that had a sunset clause. It could have expired. A lot of people try to argue, oh, this is only about the Civil War, it doesn't matter anymore, we're not in a civil war, but nonsense. This is something that was deliberately designed for a constitution that would last for the ages. And it was not supposed to just sunset. It's not just about the Confederacy. It's about what would happen if ever again there were people who either tried to set up an alternative government and thereby wage war on the United States, or who tried to overturn the central process by which our government makes a transition every 4 years from one presidency to the next. And when we had a president finally who said, and I quote, "I will terminate the Constitution if I have to hold on to power." And when he made it clear that that wasn't just words, that is, when he fomented a violent insurrection, was part of a plot to have fake ballots. All of this, of course, has to be determined by some Secretary of State or some court. But that kind of president was never supposed to get another chance at dismantling our democracy once and for all.
You know, Larry Tribe, but just as an aside, while I'm looking at you, in addition to being America's premier constitutional law expert, in my estimation, do you know you're also a fashion influencer? I just realized I'm looking at you with the t-shirt and the jacket. Were you watching Anderson Cooper Friday night? He was wearing the Larry Tribe outfit. Are you aware of this or no?
No, I'm not. But if I look like Anderson Cooper, I would do it.
Well, exactly. I consider that a win. So would I too.
Thing, Jim. That's a 3/4.
I love
That's
the
what
look.
they talk about.
Nancy Gertner, can we I promise we're going to move past the 14th Amendment in a second. So for those who are hanging their hat on the 14th Amendment, but saying we're not going to get there with that, some are also hanging their hat on a jail cell. And my understanding is unless there is an insurrection finding in some fashion, apart from the 14th Amendment, Donald Trump can not only run from a jail cell, should he be sentenced as such before November of next year, he can serve from a jail cell. Is that true?
Absolutely.
I think that yeah, that's right. I mean, I think the problem is we are in uncharted territories. I don't know how many times people can say that. I mean, this man has single-handedly, determined all the gaps in the Constitution that we are dealing with. But yes, he could serve.
Okay.
I mean, he could serve unless it depends on what he was charged with. The language of the 14th, what he's convicted of, the language of the 14th Amendment simply says took part in a rebellion. Doesn't say convicted of, doesn't say insurrection,
Right.
took part in a rebellion.
No, wait, Nancy, it says insurrection or rebellion.
It says they took an oath to support the Constitution and then and gave it. No, Larry, I'm reading it.
So am I, Nancy. But
It does say, I'm reading it too, shall have engaged
Shall have engaged in an insurrection or rebellion. You're right, or rebellion. But so the rebellion is a much broader term.
Sure.
Can we move on to the gag order?
Of course we can.
So we started this by saying that the former president went before the cameras this morning, called Letitia James a racist. He calls lots of people racist. Black people seem to be a lot of racists. That everything is a witch hunt. The judge is deranged. Everybody's deranged. Milley, the former chief of the Pentagon there and the military, he should be killed, and he may be a witness. Milley may be a witness against Trump. It goes on and on and on. So it does seem to me this is a problem, in people's minds, impugning the Justice Department and then intimidating witnesses. It's all over the place. So, Lawrence Tribe, what do we do about that?
Well, Marjorie, it's a serious problem because the legal system has not in the past had to deal with this directly. There are cases in which lawyers are subject to a gag, but the defendant, him or herself, does have freedom of speech. He certainly can criticize the prosecution. He can say, it's got it in for me. He can say the judge is unfair, but Donald Trump has gone beyond that. For example, just within the last 2 days, he said about Letitia James, the Attorney General, not just calling her a racist, but said somebody should get her. Now, when you say that about the judge, or about witnesses, when he says that Milley, who is likely to be one of several possible key witnesses in the federal prosecution, when he says that Milley should be executed, we know from the way those people who are his followers, the MAGA crowd, we know how they take his words. They take his words and then act on them. He has celebrated the attack on Paul Pelosi. He's said that the people who protest him and his crowds should be manhandled and taken out in a stretcher. You can't have a system of justice that allows someone to do that. So that if you are Judge Chutkan, you've got a real problem, because you know that anything that you will do that restricts his freedom of speech, even if it's not an exercise of any right that he has, you don't have a right to intimidate witnesses or to undermine the process of justice. Anything that he can call a violation of his freedom of speech will simply give him more opportunity to politicize the whole process, just as he did today when he showed up in New York for his trial. He used it as a platform for a speech. He will raise money. His supporters will be on his side. So she's got a problem of how, as a creative judge, to really effectuate a restriction on his speech. She has suggested that she might accelerate the trial. That is, every time he threatens somebody, she might say, well, I'm going to limit the amount of time you have to poison the jury pool and to intimidate witnesses. You're not happy with your current trial. You wanted it to be postponed further. I'm going to make it happen sooner. But Nancy, as an experienced federal judge, is much better situated than I am to say what ought to be done. What would you do, Nancy, if he were in your court and you were trying Donald Trump on the 4 very serious felony charges that Special Counsel Smith has brought against him in this 4-count indictment, and then he conducted himself the way he has so far?
He's taken over your show. He's now asking
I'm
questions.
not happy about it either, let me tell you. I'm not happy about it at all.
I promise I won't do it again.
Okay, so
I
do
mean,
some judging.
I think
He's
Chutkan
right.
has no choice but to enter a gag order as against Trump. Ordinarily, you get the case law is clear, and it certainly makes sense that the court is not like, you know, cable news. You can't just start shouting at one another. You can't say anything. You can't. There are rules that he has to follow, and the rules that he has to follow in the courtroom can't be undermined by what he does outside. I think she will enter a narrow order. I'm looking at some of the language now, that the statements that are to not have statements that are disparaging, inflammatory, or intimidating is one category. In other words, he can't start encouraging his followers to threaten people and affect violence on them. Also, the government was asking for statements about the identity, testimony, or credibility of prospective witnesses. In short, it's not just, as we often see in these gag order situations, trying your case to the media and hoping to poison the jury. This is actually putting witnesses at risk. The kinds of things that he's saying fundamentally undermine the orderly administration of justice. So she's going to enter a gag order. The question will be how she enforces it. One way to enforce it will be, as Larry was saying, which is hastening the trial date. The other way, frankly, would be financial sanctions, which isn't going to make much difference. And the other way would be to revoke his bail. And that will be a moment. But she could do that.
Judge Gertner, I know, I'm sure Larry Tribe has more questions for you, but if I can get a question in here for a second. Speaking of trial dates, why does, I don't get why Powell, the lawyer, Sidney Powell, and Cheeseborough won an early trial date in this Georgia thing, which obviously is a state prosecution. It's scheduled for October 23rd. They're enforcing their speedy trial rights. I don't get it. What am I missing?
Well, ordinarily, sort of lesser figures in a criminal case will seek to sever their case from everyone else. That's what they want to do, because they don't want to be in the pot with with Donald Trump. That's often a severance motion that doesn't work. By asking for a speedy trial the way they did, they got their severance. They had to be severed from the rest because the rest were going to claim those rights. So they want to see if there would be a trial in which they are not in which they are just not the lead players, in the hopes that a jury would hang or a jury would acquit them. And that would be a significant moment for the rest of the case. Now, the rest of the case, it would not be a significant legal moment, right? The rest of the case stands on its own, but it would be a significant, it would certainly be a significant political moment. And for the rest of the defendants, they get a chance to see a preview of the government's case. which can help them as well.
That's the voice of former federal judge Nancy Gertner. She is joined by Lawrence Tribe, professor emeritus from Harvard Law School.
You know, I didn't know there was any such thing as a jury study, Judge Gertner, which you have talked about regarding the January 6th case going on in Washington, D.C. What's that about?
Well, I just saw that actually in preparing for this. The defendants, Trump wants to do a jury study. Now, that's actually a good thing for defendants to do, to find out the attitudes in the jury pool, to oftentimes to test how much pretrial publicity there have been. I used to do that when I was a criminal defense lawyer. You get some sense of who the audience is. But the government understands, or the government fears, that what Trump is going to do is use a jury study as an opportunity to intimidate jurors, or the study will be so skewed that the results that the government then will have to be attacking the study in court. Let's say the question, instead of an open-ended question, is, don't you think that Trump is the best president in the world? Something like that. Now, of course, the judge would then, not base her decisions on the jury study, but the fear is that they would do such a study. It would be wildly skewed. It would be wildly inappropriate. And that will be part of his publicity campaign. So the government is asking for the judge to monitor that study, to get the methodology in advance and the questions. I've never seen that before, but it says something about how fundamentally Trump can try to undermine this trial.
And also he wants the evidence so he can try to get the trial moved. He says he wants it to go to West Virginia, which he calls politically unbiased, which he won by 40 points, by the way, for whatever it's worth, in the last presidential election. As we're speaking, our colleagues, Larry Tribe, just told us the Supreme Court on Monday, I'll read from Reuters, turned away a case involving whether Trump should be disqualified from the 2024 election under a constitutional provision, the 14th Amendment thing. And it appears, I don't know if you know about this because it's so current, that the lower court finding he lacked standing to sue Trump to disqualify him. As far as you know, is that the reason for the Supreme Court rejection, that this Castro guy doesn't have standing?
Yeah, there are several cases that are on their way to the court where the plaintiff plainly didn't have standing and the court below didn't have jurisdiction. So all of these kind of nuisance cases brought in the wrong court or by the wrong person are going to be tossed out. Trump, of course, is going to say, see, now the courts have already ruled for me. He's going to say the Supreme Court has ruled for me. So it's not going to, none of these PR statements on his part are going to help him in court, but he wants to be tried not in court. He wants to be tried, of course, by the people in an election, and he's going to say that he won, whether he did or not. We know the playbook. Stop the steal is going to happen in advance unless he is convinced that he's won the popular vote and the Electoral College. So,
by the way, just as an aside on this, Larry Tribe, before we get to your incredibly interesting research and potentially consequential research around Ukraine, I assume you both read the Washington Post editorial, without naming you, basically criticizing your position on this thing and the 14th Amendment, and this morning or yesterday, whenever it was, and basically saying, well, the solution is voting. But they're sort of ignoring that when he loses, he doesn't acknowledge he lost. So, I mean, it's almost nonsensical, right?
Yeah, I mean, Kermit Roosevelt from the University of Pennsylvania Law School wrote a very nice piece in which he made all of these points and said, when the solution is voting, for somebody who says he can't lose and who won't accept no for an answer, that's not much of an argument. Besides, the whole idea that this provision of the 14th Amendment is anti-democratic is nonsense. It is part of democracy to say that if you try by violence to overturn democracy, you don't get another chance. That's part of democracy. It's written into the rules. The section of the 14th Amendment that Nancy and I were both reading from is the democracy protecting clause of the Constitution. Happens to be put in terms of disqualification.
We're talking with Lawrence Tribe, a constitutional law professor emeritus at Harvard University, and Nancy Gertner, former federal judge and senior lecturer at Harvard Law School. Jim just mentioned, Professor Tribe, the piece you wrote in the Atlantic, I think it was, about especially with Ukraine's fate hanging in the balance and some people losing their appetite for funding it, about $300 billion in frozen Russian bank assets. What'd you say?
Well, it wasn't the main piece. It's not something that I happened to write in the Atlantic. It's basically a 200-page report that a bunch of extremely talented lawyers at Kaplan, Hecker, and Fink wrote with me after a 6-month study of the domestic and international laws that are all about what to do with the assets that get frozen, central bank assets, sovereign assets of a country that commits war crimes and aggression and annexes a neighbor. And the assets get frozen pursuant to various sanction regimes. What do you do with it? Do you just let it sit there? The 300 billion, this study that I oversaw, the $300 billion exists in all of the G7 countries, 35 billion here in the United States, another whole bunch of money in other countries, Canada, the European Union. Letting it just sit there is kind of a tragedy, but it turns out that a 1977 law, the International Emergency Economic Powers Act, gives the President of the United States the clear and unambiguous authority to transfer those frozen assets to the victim of the illegal aggression. That means to transfer Putin's money to Ukraine to help it defend itself and rebuild itself. And what this report concludes, and it's already making waves throughout the world, and I'm hoping that it will actually move the Biden administration to exert a leadership position. What this report proves is that first, American law, the laws already enacted by Congress, not the new laws that Congress is purportedly debating, but not very likely to pass, and international law, all of that authorizes the seizure and transfer of these assets to help rebuild the victim of illegal aggression and genocide. And I'm very much hoping that the Biden administration acts on these recommendations. There were articles and op-eds that I wrote about it, but
just to put it in context, by the way, when you were reading during the whole shutdown talk a couple of days ago, and Speaker McCarthy excluding any Ukrainian funding, Biden was only looking for roughly $25 billion.
Right.
That's 1/12 of the amount of money that's been frozen and would be available under the tribe argument here, which is huge.
But what I don't understand, though, can President Biden act by himself with the money that we have, or do all the countries have to come to an agreement about this to give back the money?
Well, we suggest it would be much more effective if it were multilateral. And I've spoken with Chrystia Freeland, the Deputy Prime Minister of Canada. She's with me on this. She's speaking to her counterparts in Italy and France and Germany. It would be better to act together, but under the International Emergency Economic Powers Act, once the president declares a Ukraine-related emergency, and has already done that, he has unilateral power to take the money out of American central banks, the sovereign central Russian bank money, and transfer it to Ukraine. We recommend a mechanism to do that, which would be multilateral, which would involve an escrow, which would involve protections against corruption, which is a perennial problem in many countries, including Ukraine. But this is an unfinished story, and it's certainly something that matters a great deal to me.
That's the voice of Larry Tribe, Professor Emeritus at Harvard Law School. Former Federal Judge Nancy Gertner is with Larry Tribe here. One last question from me, both of you. This is not in your brilliant legal capacities, but as just citizens of this country. There's almost not a day that Marjorie and I don't talk about the following, is that roughly half of the voters in this country appear to be ready to vote for a guy who has been found liable for sexual abuse of another human being, E. Jean Carroll, not to mention credibly accused of harassment or sexual abuse of another couple of dozen women, been found liable for massive fraud by this judge in the civil proceeding in New York City.
A cheat, some would call him.
Credibly accused of insurrectionist-related activity, an attempt in the English language to overthrow the government of the United States of America. Yet half the voters say he's our guy. Starting with you, Nancy Gertner, what when you sit home at night and think about this, beyond all the legal arguments, what does that say to you about this country in 2023?
I'm not sure what it says about this country right now, Jim, because I believe that it's an abstraction when you poll people now. And to the extent I just think it's an abstraction. I'm not sure that that's where people will be at the time of the actual vote. The best measure of that has been the elections since Trump won in 2016, when people actually had to go into the ballot box and did not
That's
vote
true.
for him or his, like candidates. So I think it's an easy thing to say now. Even if it was less than 50%, even if it was 40 or 30 or 20, it still would be troubling, since he is, as the days go on, more clear. It's more and more clear that he is an authoritarian, that he's a character like we have never seen hit the national stage. And were he to win, the government would be unrecognizable. So it doesn't matter what the numbers are.
You're right.
I don't think he will win, because I don't think that people will. I think that the noise is too great here around him, even if people don't believe what we believe. But it is a troubling that anyone should be supporting him now at all.
Larry Tribe, what's your reflection on that moment in time today?
Very similar to Nancy's, except that I wouldn't use the word troubling. I would say nauseating. I would say very deeply, profoundly distressing. That there are millions of people, and we always, there are always going to be some people who can be influenced by propaganda, who believe what they're told, who love the idea of turning over their freedom to a strong man and making scapegoats of others and so on. But that there are tens of millions of people who now, among our fellow countrymen, who feel that way, is really, it's very, very scary and depressing. Like Nancy, I don't think he's going to win, but he certainly won't admit that he's lost. There will be violence. People say, if he were taken off the ballot, there'd be violence. There's going to be violence when he loses, if we are right that he will lose. And the fact that there are people out there, ordinary people that I would be happy to talk to if I encounter them on the street, who seem to have their heads screwed on straight, who don't seem to be wearing, tin hats that are absorbing magic rays from the universe, who believe this stuff, is very scary. And it reminds me that the human species is far from perfect. I mean, we are rapidly destroying the planet, and on top of it, so many of us believe in crazy myths. So that's the message, is we can't give up. We have to keep trying. Whether you're depressed or whether you're just distressed or whether you're nauseated, we have to set that aside and keep working to make a difference.
Amen. Larry Tribe, Nancy Gertner, can't thank you enough. We really appreciate your time.